So, have you decided upon a course of action?
Yeah, I've decided on a course of action. I'm moving all of the opposition amendments except 7, 8, 9 and 11, which are the ones that double up the Christian Democratic Party.
9 and 11. Is leave granted? Yep. Leave is granted.
Thank you, Mr Chair. I will seek to address the opposition amendments in parts. Amendment number 1 would require that if the New South Wales... Well, I'll start. The opposition is introducing the amendments because we've got some serious concerns that the bill, as currently formulated, could have unintended consequences and unfair outcomes for people who live in social housing. Amendment number 1 would require that if the New South Wales Civil and Administrative Tribunal is considering any past breach of a tenancy agreement by a tenant, the tribunal is also to have regards to any steps taken by the tenant to remedy the breach. I think that is important. This is a reasonable measure that ensures that tenants are not unfairly punished in circumstances where they have endeavoured to do the right thing.
Look, could I just interrupt and say that there's a lot of chatter in the chamber, and I wasn't going to refer to anyone by name, and I just asked that the volume be kept down somewhat, because otherwise it's very difficult to hear the member.
Thank you, Mr Chair. Amendments 2 to 6 deal with proposed section 154 capital C and will increase the time frame for tenants to make submissions in response to a strike notice that they have received. This time frame has been a key area of concern for stakeholders, as the Shadow Minister in the other place outlined in her second reading speech. I note that the government originally proposed a 14-day timetable, but amended their own bill to provide tenants with 21 days in which to respond. The opposition still considers that this timeframe is too short, particularly for vulnerable persons who would need to organise access to support services such as interpreters, community legal centres or other support persons in order to make a submission. Accordingly, we propose to give tenants 28 days to respond to a strike notice. I note opposition amendments 7, 8, 9 and 11 are the same as Christian Democratic amendments 1, 2, 3 and 5, so I don't move those. But I do move opposition amendment number 10. This deals with proposed section 154 capital D, and the underpinning notion informing the opposition amendments in this area is to provide the tribunal with greater powers to exercise discretion when being called upon to terminate a tenancy. The opposition believes the tribunal's capacity to exercise discretion is an important safeguard against harsh and unjust outcomes being applied to vulnerable persons who may have done nothing wrong. We do not believe that a one-size-fits-all approach is appropriate, and the amendment number 10, will expand the tribunal's capacity to exercise discretion in order to take account of the specific circumstance that applies in individual cases, and in particular it will not apply if the application for the termination order is based on the act of a person who, although not a tenant, is occupying or jointly occupying the residential premises. And if the application for the termination order is based on an intentional or reckless act of such a person, then the subsection would not apply in the same circumstances, where a person, although not a tenant, occupying or jointly occupying the social housing premise, the offence would not apply unless the tribunal was satisfied that the tenant knew or ought to reasonably have known that the person was committed the act or was complicit in the act, or failed to take reasonable steps to prevent or report the act. If a provision is disapplied by this amendment, were it to become part of the legislation, the tribunal would retain a discretion as to whether or not to make the termination order in circumstances to which the provision would otherwise apply. The effect of the amendment would be to not render it automatic or inexorable. You can imagine a situation where a tenant has a person living with them who does the wrong thing. The person may be a common law partner or a relative or what have you. We think it would be unjust if the tenant was to be punished for that person's transgressions unless the tenant knew or reasonably to have known that the person was committing the act or complicit in the act. It should not be automatic. The tribunal would retain the discretion, but wouldn't have to. There would not be an automatic exclusion from the premises. Amendment 12 would guarantee privacy for persons who make submissions for neighbour impact statements. We believe this is necessary in order to protect law-abiding citizens who report illegal or antisocial behaviour from being subject to harassment or reprisals. Amendment 13 provides tenant with a reasonable opportunity to respond to a neighbourhood impact statement, which is a reasonable safeguard against the potential misuse of these statements, as it provides tenants who are subject to such statements with a degree of procedural fairness and natural justice. Amendments 14, 15 and 16 propose a distinction between the minimum number of days required for an order of possession for reasons pertaining to antisocial behaviour and other circumstances, such as when a social housing tenant is in financial distress and does not have the capacity to keep up with rental payments. The intention of the amendments is straightforward. New South Wales faces a housing affordability crisis, and it's necessary to differentiate between tenants who have displayed antisocial behaviour and tenants who are suffering hardship for financial reasons and seek appropriate alternative accommodation. The opposition's amendments look to 60 days notice, not 28 for those who have committed antisocial behaviour. Amendment number 17 deals with proposed section 156 capital A. The opposition's amendment will give tenants the opportunity to satisfy the tribunal that their failure to make a submission against the issuing of a strike notice in the relevant time period was the result of factors outside their control or some other reason. This would ensure that a vulnerable tenant, such as the victim of domestic violence, I think it's a very important factor that we should all bear carefully in mind, who do not have access to their mail due to a controlling partner, or a tenant with an intellectual disability, or a tenant from a culturally and linguistically diverse background who would not have had the opportunity to contest a strike notice, would not have held against them as conclusive proof of that allegation their failure to respond if they did not have a legitimate reason for their omission in responding. The amendments are reasonable and informed by the opposition's consultation with stakeholders, as well as the experience of Labor members of Parliament across the state working with social housing tenants in communities across New South Wales, and I commend the work of our Shadow Minister in the other place for her work in consulting with affected parties, stakeholders, and in putting together the opposition's amendment. Mr Chair, with that, I move opposition amendments 1 to 6 and 10, and then 12 to 17 in globo.